Hello, hello. Hi, hi, hi. Hi, everyone. Good afternoon. Actually, good morning. Good afternoon to Sam. Today, I'm going to be brief. I'm going to talk about the prosecutorial discretion in immigration proceedings. I have prepared a PowerPoint presentation for you to to watch as I'm speaking. So let me. Good morning. Okay. Good afternoon to Sam. Yeah. So let me go. Yeah. So I'm trying to broadcast. So how are you? My name is Claudine Gasana. I am an immigration attorney here in Houston, Texas. I, I come here always to provide more information, more updates in immigration law. Trust me, there's always something new going on in immigration. So today I actually prepared something very important in the prosecutorial discretion, and it's something new. Something it's not new, but it's something that the Biden administration it is now pushing forward. So I want to know if your attorney approaches you and tells you about the prosecutorial discretion, or if you are not represented and you receive mail from the ICE, Immigration Customs Enforcement or DHS attorney, like something in the mail saying they are filing a motion to dismiss or they are providing a prosecutorial discretion. What are they talking about? So that's what I'm coming here to discuss with you. So let me share my screen. Oh, okay, first of all, yeah, let me share my screen and let's see what we got. Bear with me. Should be here somewhere. Actually, hold on just a minute. Bear with me, guys. I should have it open somewhere. Let me make sure. So, and please share, um, subscribe, comment, like. This is very important. If you have any immigration proceedings, if you are in court, you have an asylum pending in court, you have anything pending in court, you are in court. Yeah, give me 1 moment. I'm just trying to open it. If you have any case in immigration court, you are in removal proceedings, then you need to listen, you need to follow along because this is very important. If you have been in removal proceedings for a long time, you have cases that have been pending for months, for years. Now it is the time to watch this video in the fullest. It's not something like breaking news, one of those like information you hear, like buzz information, but this is very important if you have a case pending with immigration, or if you have a friend who have a case pending in immigration court with the immigration court or on appeal, because it seems, and yesterday we had a meeting with the office of principal legal attorney, which is a new term for the DHS attorney. And then what they told us, it is interesting, and what we have been seeing in the practice, it is very, very interesting, guys. So that's why I need you to watch, I need you to share, I need you to subscribe, because this is gonna touch your case. You have a case pending, you have an asylum case pending in immigration court, you have a cancellation of removal case pending in court, and you are working, you have a work permit. You may not have your work permit anymore because of what I'm about to tell you. We had a meeting yesterday with the attorneys from the DHS, and they told us what is their preference. Like, what they are trying to do with this prosecutorial discretion, which really it should be a tool used to help those who should not be in court. But some people, what they have, it is that case pending in immigration court, and if you take it away, they may stay here in the United States, but they may not be authorized to work in the United States. So let's dig in. So I'm here to tell you, first of all, what is the prosecutorial discretion? Again, for those who are tuning in, this is Attorney Gasana, immigration attorney here in Houston, Texas. I'm here to always let you know, always alert you on what's going on in immigration, what can affect you, and what you can do about it. So the prosecutorial discretion, I'm not going to go through all this language. My team is very good. They have prepared a good PowerPoint presentation. You can read along. You can go back and read. Basically, a prosecutorial discretion is how it sounds. So the the U.S. immigration agencies in charge of prosecuting immigration cases has a discretion, has power to decide which cases they are going to pursue in court, in which cases they can dismiss, which cases they cannot dismiss on their own, they can move to dismiss. But sometimes a case may not be even in court. So that's when the DHS can decide which case to try, or which document to issue a notice to appear, to charge a document, to charge to issue a charging document and start the removal proceedings. ICE or DHS or even USCIS can decide when to pursue in a case and when not to just leave it alone. So that's basically what the prosecutorial discretion is, and we will see what are the benefits or what can be done with the prosecutorial discretion. Just watch with me, bear with me. So who is eligible? So in theory, a non-citizen, and I say here non-citizen because sometimes somebody who has a green card can be also subject to removal proceedings. That's why I always advise people to seek citizenship as soon as you become eligible. Any non-US citizen who has who is in removal proceedings can get a prosecutorial discretion or can be eligible because you do not give it yourself. Again, the ICE attorney or the DHS attorney, they have that discretion to move to dismiss a case. And usually they look at the family ties, you have a good employment history, you are a good member of the community, you have no criminal record. So, and maybe you have family members who are sick. Those are usually what we call equities for the prosecutorial discretion eligibility. Right, so what are the benefits of the prosecutorial discretion? And here, that's where I'm going to spend more of my time. And I'm going to give you examples. So the prosecutorial discretion, usually when we have a case pending in court, as the attorney, as a private bar, we can approach the Department of Homeland Security attorney, who is the opposing party. Again, when you are in court, you as a non-citizen, you are there facing another attorney who is the government. The government really is asking the judge to remove you, to deport you. And you are here seeking relief, saying, no, you cannot deport me because A, B, and C. So before we even get it in front of the judge, you or your attorney can approach, usually that's how it's done, can approach the government attorney and ask them, look, this client of mine, here's the case, the asylum case, here are the, here are the facts of this client's case, here's the evidence. Is there any way we can meet in the middle? Or if somebody has an asylum case pending in court, but they are married to a US citizen, then your attorney can approach the DHS attorney, hey, can we move to dismiss this case so that we can pursue the adjustment of status because my client is married to a US citizen? Or you have a TPS, I have given a video on TPS. You have a TPS, or you have DACA, or you have U visa, or you have a VAWA case pending. So, and then you could approach the government attorney and ask them to move to dismiss or to terminate the proceedings, right? So that's usually the main benefit of the prosecutorial discretion, is to get your case terminated or your case dismissed from removal, because you are being, you are being set up for removal, you are in removal proceedings. So the PD, usually the main benefit will be to terminate the proceedings so you can pursue other routes to get you to a permanent residency, or even to a temporary, but you don't have to worry about being deported. That's the best option. But however, we will see sometimes this may not be a good option for all people, right? So some other issues will be to administratively close a case so you can pursue like 601 waiver. So these are basically the benefit of the PD. Or in case you don't really have any other option, like you have the case, you have an asylum case, and that's your own option. You have no other option. You don't have TPS option, you don't have VAWA, you don't have U visa, you don't have cancellation of removal, you don't have a marriage or a family member who's petitioning for you, and your only option is asylum. Sometimes we use PD request to ask the government to stipulate on the some of the facts or the evidence, so that your case can go smoothly. In a case, sometimes they will not stipulate, and that's what they said in our meeting. They're not going to stipulate on relief, on the entire relief, but they can stipulate on some of the facts, such as credibility. They can stipulate, okay, this person has, maybe past persecution, or this person has basically it's mainly credibility and some of the evidence, like, okay, the country conditions on that stuff. Okay, so what else? And you can read the rest of this. I don't want to bore you with most of this information. You can go back and read. So I'm just telling you. So now, this is the juicy part. You better stay here. Again, I'm discussing the prosecutorial discretion. So now, how is this PD being applied by the ICE and DHS attorneys? According to the memo, the Doyle memo of April 3rd, 2022, this memo came into effect last April 25. So I'm not gonna read all this. I'm just gonna give you what's happening on the ground, on the ground. So this is the memo. Yeah, you can read all this language, all this stuff, but let me tell you what's happening. So I had a case pending with immigration court. That was before this memo came into effect, because this memo came into effect on April 25th of this year, right? So I had a hearing like a few weeks before that, prior to that. The first thing we go in court, we have prepared. It was a good case, a solid case. We have prepared, we were ready to move forward. But before we even proceed, the first thing the judge asked, do you guys need a continuous? A continuous is also like to postpone the hearing, so you can see if you will apply for the PD, the prosecutorial discretion. I was confused. The judge, that's literally what he asked the first time, when he came into session before, like, when you go to court, you have these preliminary matters before they go on record. They ask you, the attorneys, have you discussed this case? Is there any stipulation? But before he even asked that, he asked us if we need a continuance so we can go discuss the PD. I guess he was, anticipating this prosecutorial discretion will come into effect on April 25th. But then I was thinking, my client really doesn't have any other option. There's no pending I-130, which is marriage petition. There's no pending other relative petition. There is no TPS available for him. There's no VAWA available for him. There's no U visa available for him. There's no 601 waiver. There's nothing available for this client other than the case we were advancing in court. And then, I was like, Joanna, let me talk to my client, but this case has been pending for years. We have been preparing for years. They have been scheduling, rescheduling. So no, my client was like, no, we don't need to continue this case. We will argue this case. But we went on to argue for 4 hours, and the case was very good case. I mean one of the strongest case, but the judge had his mind set up or made up, and of course he denied. But that's okay. If we have taken that option, then the client will be left with nothing. You will be here, you don't have status, so you cannot work, but you cannot even leave, and you are here just in the mass of the population with no status. So that was not the best option, right? So, and that brings me to what the meeting we had yesterday with the Houston Office of Principal Legal Advisor, which is the new term for DHS attorney. And they told us that their preference is to dismiss all cases. Basically, as you have heard, like the issue that in immigration right now is that all the courts are backlogged. The courts are backlogged. So now they are using this PD, and then keep moving so you can read more. Okay, yeah, they are moving this. They are using this prosecutorial discretion option or benefit or request to alleviate the backlog. So to show to me that, okay, you see, we have, so that at the end of, the Biden administration, they can, so we have freed the courts system, immigration courts from all this backlog, but they are leaving people who are non-citizens with no option, like with no option. So that was my case. And then the other attorneys have been reporting, you have a good cancellation of removal. So those who don't know the cancellation of removal, if you have a cancellation of removal casing, basically, I'm not going to go into details, but it's you have a pending cancellation of removal. You are able to continue working while your case is pending. And if you have a cancellation of removal, it means if you have a good case, you are going to win, and you will become a legal permanent resident. Even those cases, they are being dismissed. They are moving. The DHS is filing unilateral motion to dismiss a case. Doesn't matter if they have any other options or not, because that's their preference. So that means, usually the private bar will have to request for the PD. Now the attorneys from the ICE attorneys, the DHS attorneys, or Office of Principal Legal Advisors are moving. They are proactively filing those unilateral motions to dismiss. And unfortunately, some judges, they are going with it because they just want to read their dockets, but that's not going to work. So now let's get back to really who should not be, who should get a priority, who are the priorities. So basically they have these three categories. They have priority A, those who have criminal records, who have threats to the national security, and they have also they have what is it? Yeah, terrorism, criminal, this category A and B. So these are terrorists. Priority A, those they cannot benefit from the prosecutorial discretion. But the priority B is criminal record. Yes, serious conduct. You have a felony. You have a couple, 3 DUIs. Probably not going to benefit from this unless really you can provide like some evidence of good factors, like equities. You have rehabilitated, you have ties in the community. So, and then there's this who are not, so category C is those people who came at the border, who came unlawfully after November 1st, 2020. They will not be they will not benefit from the PD. Everyone else is benefiting from the PD, for better or for worse. Like I was explaining, if you had a case pending for 10 years or for 5 years and you have an asylum case, or you have a cancellation of removal case, and that's the only way, that is the only option to stay in the United States, to be able to work, to be able to get your case a chance to be heard by a judge, And by the way, remember, even if you don't prevail in court, you can always appeal, but they are taking away all that. They are taking it away, so you don't have it. Yeah, this is what I was saying. They will, so you will not have your work permit you've been using for all these years. You don't get to plead your case in front of the judge, because the judge, they are dismissing asylum cases. Yes, they are. Like, I'm not making this up. This is, we have our forums as attorneys where we share, because they preferred, um, uh, what they prefer. You mean when I say they, is ICE attorneys, they prefer dismissal, because they just want to get all the cases out of the dockets, so they can say we have freed the immigration courts of these backlogs. So, so okay, so this the whole like, again, you can go ahead and go back and read. Okay, so this is what I was saying, and this was really my main reason to even give a presentation on the prosecutorial discretion, is that PED, which is a prosecutorial discretion, is not always the best option. Actually, is not even a good option at all. If you have a pending asylum case, and that's your only relief, or if you have a pending cancellation of removal, either based on being a permanent resident or a non-permanent resident, cancellation of removal, you have lived here for 10 years, or in case of a resident, 5 years, and then you got into trouble, you were put in removal proceedings, you usually apply for your work permit and continue working, and you get your case heard by an immigration judge. If you don't prevail, you go to the Board of Immigration Appeals. If you do not prevail, you go to a federal court. So all of this is going to be taken away, and you will be given prosecutorial discretion, meaning we're not going to deport you, but you may not be eligible for work permit, because there is a difference from prosecutorial discretion and deferred action. So those are two separate, options. One gives way to apply for a work permit, the other does not necessarily do. So that's why before you even, if you are not represented by an attorney, or if your attorney just want to say, okay, let me give you the PD, let's apply for the PD, ask your attorney, so if we do apply, what am I gonna be left with? Can I continue working? Can I continue driving? Can I continue to live here, like drive without no problem? Or do I have any other option? If you do, yeah, that's good news. If you have any other options, like I was saying, like a VAWA, like visa, TPS, DACA, or green card, then green card meaning a family petition or any other petition, that there will be no, because if you don't have a family petition, immediate family petition, also you'll be have an issue over an offer presence, which may not be, well, you may be eligible for some type of a waiver. So that's why you need to seek counsel before you make a decision on the prosecutorial discretion. So basically, to finish, and these are the statistics again, you will see, you can see for yourself, and this is what's going to happen, because they want to remove or free the courts or unclog the courts with all the pending cases. Yes, there are cases that are pending in immigration courts system that should not be pending, because they shouldn't be there. It should be there. If somebody can adjust status with USCIS, if somebody can pursue or can stay here because they have another semi-quasi status like TPS, then there's no need to put them into removal proceedings, right? But there are other cases that should stay in court, because that's the only option you have, and they should not group all of their cases pending in court in one vacuum, right? So that was it. Prosecutorial discretion, it could be a good option for you. Always contact us if you have any individual question you want us to review your case, and please share with your friends who have been here for a while and who have their cases pending in court. So they know they might not be able to continue working if they get this PD. If they don't have an attorney, they should seek an attorney, because what is happening is they will start with cases for those who have attorneys on the file, and then they will move to the cases who are not represented. So, and if you're not represented and they give you this legal language and you're gonna say, I don't know, just do what you can, that's not a good idea. So I'll seek counsel. All right. So I thank you, and please, as you see, you can subscribe and share and follow. And then now stop sharing my screen. I hope you benefit from this presentation. I hope it wasn't too long or I didn't talk too much, but you can go back and review these PowerPoint slides. That's why we keep them here, so you can share with your friends. You can share with your, or you benefit if you are, that's like, if this pertains to you. So let me wish you a happy weekend. I thank you all for always tuning in, and have a great weekend. I will see you soon. Bye.